thought about this? What would actually happen if someone sued you and you just did nothing? Like completely ghosted the lawsuit? Does it all just go away? Or does something else kick in? Well, let's get into it.
All right, here's the plan. We're going to walk through the whole thing. First, we'll talk about the no-show defendant. Then, we'll get into the weird one-sided trial that happens next. We'll also look at the judge's role, see if you can turn back the clock, and finally, check out the court's ultimate power to fix things.
So imagine this. A summons lands on your doorstep. You see the paperwork, and you just ignore it. Toss it in the counter and forget about it. What happens then? You know, in the world of civil law, silence isn't really a strategy. Nope, it's an action, and it has some pretty big consequences. Okay, so let's start with Section 1, the no-show defendant. When you don't respond or show up to court, the legal gears don't just grind to a halt. Far from it. Instead, you're officially considered to be in default. And that word, default, is a really big deal. Let's break down exactly what it means. Yeah, the legal system actually has a super clear playbook for this exact scenario. It's all laid out in the Civil Procedure Code, and specifically, we're looking at Section 84. This section spells out precisely what it takes for the court to say, all right, this person is in default. So when does this actually happen? It's not like you miss one email and you're done for. The court gives you a few chances. You might fail to file your answer by the first deadline, or maybe they give you another date and you miss that one too, or you just straight up don't appear for the hearing. If you do any of these, the court basically says, okay, we've done our part, and gets the green light to proceed, without you. And that brings us to our second part, the one-sided trial. See, once you're officially in default, the case doesn't just get stuck in limbo. Nope. The court moves forward with a very particular kind of hearing. It's called an ex parte trial. So what is ex parte? It's a fancy-sounding Latin term, but it's pretty simple. It literally means from one party. And that's exactly what it is. A legal proceeding where only one side, the plaintiff, the person suing you, is there to make their case. Your side of the story? It's just not there. Because, well, you're not there.
Now here's a really important point. The person who sued you doesn't just win by default. It's not automatic. Think about it like a sports game where the other team just doesn't show up. You don't just get the trophy handed to you, right? You still have to kind of play the game. You've got to show the ref, in this case, the judge, what you've got. You have to present your evidence and actually prove your case.
Which brings us perfectly to our third point, the judge's duty. This part is absolutely critical. The judge isn't just a bystander here. They're not just a rubber stamp. This is a real trial, and their job is to make sure it's a legitimate one.
In fact, a really important court case, Srimava Bandarnake versus the Times of Ceylon, said it perfectly. It's the duty of the judge to act according to the law, even in an ex parte trial. Their job is to put the plaintiff's case under a microscope, making sure it holds up, even when there's no one in the room to argue against it.
So the judge has this sort of checklist they have to run through. Things like, okay, was the defendant actually served with a summons? Did they even know about this? Is the plaintiff here in court? Does the evidence they're presenting actually prove their claim? And the big one, is this claim even legally valid? The judge has to be able to say yes to all of these questions before any kind of judgment can be entered. All right, so let's say the ex parte trial happens, and the judge rules against the person who didn't show up. Is that it? Game over? Well, not necessarily. This leads us to Section 4, turning back the clock. The law actually provides a way to maybe, just maybe, get a second chance. So is the decision final? That's the million-dollar question for anyone who's been ghosting a lawsuit, right? Is there any way to undo this? And the answer is yes. But, and this is a big but, it's not a walk in the park. The key can be found in another part of that same rulebook, the Civil Procedure Code. This time, it's Section 86. And you can think of this section as a kind of legal escape hatch that lets a defendant go back to court and ask them to throw out that ex parte ruling. So how do you use this escape hatch? Well, first, you have to formally apply to the court and let the plaintiff know you're doing it. Then comes the hard part. You have to prove one of two things to the judge. Either you have to show that you were never properly served the summons in the first place, or you have to prove you had a genuinely good reason for not showing up. If you can convince the judge, they can basically hit a reset button on the whole thing. Okay, but what if something is really wrong with the whole process, like fundamentally broken? That brings us to our last point, the court's ultimate power.
The legal system has one last safety net for those really extreme cases, and it's called the court's inherent powers.
This is covered under Section 839, and it's reserved for some pretty serious screw-ups. The classic example is if there was no service of summons at all, meaning the court system completely failed to notify the defendant that they were being sued. If that happens, you can see how the entire case is built on shaky ground, right? And that's when the court can use these powers to step in.
And that's really the whole point. This inherent power exists to stop the legal process from being abused. It's the ultimate safeguard to make sure that a simple mistake or a procedural issue doesn't end up causing a huge miscarriage of justice.
Which really leaves us with this final, big-picture question. How does the legal system pull off this tricky balancing act? On one hand, you need cases to have an end. You need finality. But on the other hand, everyone deserves a fair hearing. It's this constant push and pull between efficiency and justice, a tension that's really at the very core of how our legal system works.